I remove my mask, Your Honor.
Yes.
Good morning. May it please the court. My name is David Stradley. I'm here with John Bloss on behalf of the plaintiffs' appellants in this matter. I come before you today to discuss two errors that the district court made. First, the court misapplied the Supreme Court's Reno versus Condon opinion using language that expressly dealt with Section 2721 of the statute to restrict the scope of Section 2724, even though Congress used different language in those two sections. And secondly, and perhaps more primarily, the district court ignored the plain language of the statute in the absence of any showing that the plain language was either ambiguous or yielded an absurd result in this case. In other words, the district court interpreted a statute that was in need of no interpretation. Turning to the Reno issue first. The Reno case was the first time the DPPA went to the Supreme Court. And therein, the question was whether the DPPA was a constitutional exercise of congressional power under the Commerce Clause. And the court there dealing with the case dealt with 2721, which was a restriction on what DMVs can do. That's what Section 2721 talks about. And the Supreme Court remarked that the DPPA in Section 2721 regulates what DMVs can do with information, the release of information held by state DMVs. But the court then went on to say that, quote, additionally, any person who obtains, discloses, or uses information from a state motor vehicle record for a use other than specifically permitted by the DPPA may be subject to liability. In other words, the Supreme Court, like Congress, recognized a distinction between 2721 and 2724, and that is where the district court got confused. The district court held that the DPPA only regulates information in the hands of a Department of Motor Vehicles. And that ruling defies both the language that Congress used and the structure of the DPPA. And further to suggest that the Supreme Court's choice of language, when the Supreme Court, like Congress, distinguished between information in the hands of a state DMV and information from a motor vehicle record, when they use different language, we owe them at least as much deference as we owe Congress, that when they use different language, they mean different things.
Are there any, counsel, are there any circuit courts that have adopted your view of the statute and said that it applies to something like a crash report or a driver's license or to records outside of the Division of Motor Vehicles?
A crash report, Your Honor, I don't believe has come before a circuit court, but information outside of the DMV has indeed come from before a circuit court in the Pickler decision. And in that decision, the information was gathered, the DPPA protected information was gathered from Westlaw and from other information brokers that were not directly from DMV. Certainly some cases the data has come directly from DMV, as in the Marisich case from the Supreme Court. But in the Pickler case, the information did not come directly from the DMV.
Why does that matter?
Why does where the information comes from matter? That is what the district court, that's the distinction the district court employed, Your Honor, to dismiss our case. The district court says if it doesn't come directly from DMV, it's not protected by the DPPA. But the statute, we certainly argue, says otherwise. The statute, Section 2724, specifically says that the DPPA protects information from a motor vehicle record. And a motor vehicle record is defined.
Well, does this come either directly or indirectly from the DMV?
Yes, Your Honor.
How is it traceable to the DMV? The information that the defendants were, you say, violated the DPPA. Was that information that they obtained either directly or indirectly from a DMV?
It is information that that certainly originated with the DMV, Your Honor. And the evidence in the record shows here that the information was obtained either from, in the first instance, either from a driver's license or from the DMV's database. That is established by affidavit as to each and every one of the plaintiff's appellants, that the information came from the driver's license or the DMV database, both of which are DMV records, was then placed on the crash report, and the crash report had a box checked that indicated that the information on the report was the same as the information on the driver's license, i.e. was.
So it seems to me the gist of what you're saying is that no matter how tenuous the relationship of the particular information is with respect to the DMV, that's covered by this statute.
Well, Your Honor, I would.
You're willing to let a very tenuous and indirect relationship with the DMV to bring the license or whatever within the coverage of the statute.
Well, Your Honor, we would argue that it's not tenuous. It is certainly did not come directly from DMV. But in this case, we have information that by statute in North Carolina, the drivers had to hand over at the accident scene. That's a legal requirement, and that information was taken directly.
Well, I'm sure, but in every instance, a driver's license is going to have some connection with the DMV because that's what you get mail from the DMV, and it says, okay, fill this out. You have to maybe go into the DMV and take an eye exam, or the driver's license has something on it that has the expiration date, and the expiration date is set by the DMV. So every driver's license in the world has some attenuated, at least, connection with DMV, because the DMV ultimately issues the license. But does that bring every driver's license in the country within the protection of this statute?
Yes, Your Honor, at least in the first instance. And I'll point.
What do you mean the first instance?
At least to begin with. Now, obviously.
To begin what? To begin, I don't understand. Where is the begin? What does that mean?
Sure, Your Honor. If I give away if I go into a store and hand them my driver's license and voluntarily give up my privacy right, then perhaps my DMV information is no longer protected because I gave it away. It's a statute designed to protect privacy, and I've given up my privacy voluntarily. That is not what we're dealing with here. We're dealing with here an involuntary extraction of information from these North Carolina drivers, which is exactly what Congress intended to regulate here, is this involuntary extraction with the DMV.
No, that's really not exactly what Congress intended to regulate, is it? Because Congress intended to regulate the abuse of these vast trove of information that exists within state DMVs. And the state DMVs were using this vast trove of information for commercial purposes and as a revenue-raising mechanism. And when you combine the text with the legislative history, don't you get the idea that this was aimed at a particularly egregious misuse of privacy information, including driver's history and medical information and all kinds of things. And they were using it to raise revenue. When you look at the history of this and what brought the statute into being, it was that was its focus. It's an anti-commercialization statute in that sense. Isn't there all the difference in the world between using the information within a DMV to raise revenue and covering driver's licenses, which the individual who holds the driver's license is using it for all kinds of identification purposes?
And Your Honor, perhaps there is when the driver is using it for all kinds of identification purposes. That's not what it was used for here.
But potentially it is, because every driver's license, once it's issued, it is probably the most common means of identification in the country. I mean, people say, well, let me see your driver's license when you rent a car, or let me see your driver's license when you go to vote, or let me see your driver's license when you go to buy an intoxicating beverage. So something that is shown regularly for public inspection to all kinds of different people, isn't that dramatically different from the misuse of records containing the most highly sensitive medical information, for example, within the DMV? Aren't we talking about, apples and oranges?
Well, Your Honor, I would suggest that there certainly are distinctions, but the key distinction here, you mentioned commercial purposes. That is precisely what these records were used for in this instance, is, harvested in bulk for commercial purposes, which is precisely what Congress was intending to regulate. And in terms of the question of whether Congress intended the driver's licenses to be covered, one only has to look at Section 2721E of the statute, which talks about the issuance of motor vehicle records by the DMV. And so it is, the things that are issued by DMV are licenses, registrations, ID cards, the very kinds of things that we're saying are covered by the DMV. And 2721E says that the DMV cannot condition the issuance of a motor vehicle record.
Well, the appellees didn't get the information here from the driver's license.
Excuse me, I'm sorry.
The appellees did not get the information here from the driver's license, did they?
That is correct. The appellees did not get the information from the driver's license, but again, a motor vehicle record is quite broadly defined as anything that pertains to a driver's permit.
What is the limiting principle in what you're saying? That a motor vehicle record is anything that pertains to a driver's license ad infinitum?
Well, Your Honor, in terms of the limiting principle that would apply to this case, the DPPA certainly protects information that is obtained involuntarily from a DMV database or a license where the means of obtaining it show that the information is connected to the driver's license, as it did here. The crash report shows it comes from it is the same as the address on the driver's license.
But following up on that point, I want you to focus on obtained, what that means, and obtained from. And it doesn't seem to me that the information you have here was obtained from any of the things that you think are motor vehicle records.
Well, Your Honor,
there was a step removed, right?
No, Your Honor. I would argue that it doesn't matter how many steps removed it is.
Did you look at the driver's license, the actual driver's license?
No, they did not.
Well, you didn't obtain it then from the driver's license, did you?
Well, but the Congress in the statute indicates that its intent is to regulate the consumption of this information downstream.
Well, I had always thought that what we did was first look at the statutory language.
Yes, Your Honor.
And the statutory language says obtain personal information from a motor vehicle record, which would indicate to me that you had to obtain it from the record, not some copy of the record, not some document that's made from the record, but from the record. And then after we look at the statutory language, then we look at intent.
Well, Your Honor, I would suggest to you that if that is the rule,
Yes.
then the statute is can be readily circumvented. Because if that is the case, then a copy of the driver's license is unprotected. So, for example, when I go to the DMV, they could give me my license, they could make a copy of it before they give me my license, and then it is no longer protected because it is not from a motor vehicle record. The license would be the motor vehicle record. And it is clear from the structure of the statute, both the 2721C, which talks about redisclosure of information, and Section 2724, under which we sue, that the protections do not stop at the DMV door. This is a comprehensive scheme to regulate both the supply of DMV information.
What language are you relying on that say it doesn't stop at the DMV?
Well, Your Honor, if you look at section 2721 C, that
a question here and one and to what extent crash reports and driver's licenses, public records, open to public inspection?
Well, certainly under the terms of the DPPA, they are not, Your Honor.
No. I'm saying generally as a matter of state law, are these records, be it a crash report or a driver's license, this would be a matter of state law. And to what degree are they open for public inspection? To be
Your Honor, under state law in North Carolina, the crash reports are public records. However, the DPPA under the supremacy clause trumps state law.
Well, I understand that, but we don't lightly invoke preemption and everything unless it's a matter of congressional intent, and congressional intent has to be clear. And if we took your view, I'm wondering if we wouldn't be overruling a host of state laws that have provide that crash reports and driver's licenses are open for public inspections, particularly crash reports. And the states do this as part and parcel of their police power to ensure public safety. Now, if we took your view of things, wouldn't we be overruling a host of state laws, and wouldn't that be a loss in transparency? And having these things off bounds to any kind of inquiry, that's a very big step that you are taking in terms of transparency. And I'm wondering if there isn't some advantage to having these records open for public inspection.
Well, Your Honor, there may be, but Congress has made the policy decision here.
Well, no, you're assuming the conclusion there. That's what we're trying to find out.
Well, I don't think I am, because the whole point of the DPPA was to regulate state practices and to overrule state practice and state law. And that's what
the question is, a matter, as it often is in law, of one of degree. Yes, it was to overrule state practices, but the state practices that we're talking about are the ones that we have just gone over, which is the casual misuse of, as I say, a wealth of private information. That doesn't seem to me, the same danger doesn't seem to me present with respect to crash reports and driver's licenses. Driver's licenses don't have the driving history, and they don't have medical information on the driver's license or on the crash reports, and yet they would at DMV. I mean, you're talking about with DMV all kinds of personal information that isn't present when you're talking about a driver's license.
Well, Your Honor, you are talking about some pretty sensitive information on a driver's license, for one thing, and certainly in the case of at least one of the plaintiffs here, Mr. Blakesley, the report that was obtained contained his driver's license number. And that is certainly exposing him to some identity theft concerns. So, I would argue that the driver's license database is precisely, and the information on driver's licenses was precisely the information and the types of information that Congress intended to restrict.
Can you get back to Judge Motz's question that I don't think I heard an answer to it? Her question was, what language are you relying on that says the protection does not stop at the DMV?
Sure. If you look at section 2721C, Your Honor, I apologize for not getting that. If you look at 2721C, it says that an authorized recipient of personal information may resell or redisclose only for a permitted purpose. And so Congress has in mind here that once this information leaves the DMV door, that it is continuing to be regulated because it talks about the resale and redisclosure. And if the appellees are correct, 2721C goes out the window because there would be no reason to regulate resale or redisclosure if the only thing that was protected was information in the hands of DMV. So that section in and of itself shows that there's an intent to regulate beyond the doors of DMV. And when you couple that with section 2722, which makes it unlawful to obtain the information without a permitted purpose, and section 2724, which creates this cause of action, the structure of the statute demonstrates that there was a clear intent by Congress to regulate outside of DMV's front door.
Did your clients ever, I'm sorry.
No, you go ahead.
Did your clients ever see an actual driver's license?
Did my clients see a driver's license? My clients are the plaintiffs, so that was their driver's license.
Did anybody obtain a driver's license in this case?
No one obtained a driver's license.
Okay. Did anybody obtain anything else that you regard as a motor vehicle record?
Yes, Your Honor.
What?
Information.
No, I'm not talking about information.
A tangible document. Well,
yes.
First of all,
Reading the statute that says obtained from a motor vehicle record.
Yes.
But so from a motor vehicle record sounds like it's a tangible document, right?
Right.
Okay, so what information was obtained from a motor vehicle record? Directly.
Our client's information was obtained from an accident report, and an accident report is a motor vehicle record.
Did you argue that below?
We argued that the information on the accident report was information from a motor vehicle record.
Well, but you waived the argument about whether, remember you briefing all through the sort of things changed as they do, to be sure, as you go along, but you never argued that finally. Your final position wasn't with respect to that.
We argued that. We attempted to argue that on a motion to reconsider, Your Honor.
Well,
but that was denied.
So the fact that you attempted to argue it on a motion to reconsider is clear indication that it was not argued before.
I think I have to concede that, Your Honor.
Thank you.
Okay. I'm sorry. Now I interrupted you.
No, I'm good.
So, in sum, as my time is about up, where information is obtained from a document that shows it's connected to a motor vehicle record, and that information has been involuntarily extracted from a plaintiff, the plaintiff should have a cause of action under the deed.
All right. We thank you very much. And you have some rebuttal time that you've reserved. And Mr. Learberg, we'd be pleased to hear from you, sir.
Thank you, Your Honor. May it please the court, Matt Learberg for the appellees. The plaintiffs today are asking for a lot. They're asking for this court to ignore a unanimous Supreme Court and its pronouncements in Reno versus Condon about the reach of the DPPA. The plaintiffs are asking this court to reject the statutory interpretation of virtually every other court in the country to consider the statute. They're asking the court to contravene the position of the Department of Justice as to what the DPPA means. And finally, they're asking this court to hold that the defendants violated federal law by obtaining and using public records that the government itself had already made public. I want to address.
I suppose you could say that the plaintiff's position has a certain intuitive feel because a driver's license, it gives you a license to drive, and what are you driving? You're driving a motor vehicle, and so in that sense, the driver's license, which allows you to drive a motor vehicle, pertains to motor vehicle records. I mean, that's the intuitive appeal of it, is it? Do you understand that?
Yes, Your Honor. And there's two problems with that. First, most courts in the country have held that the driver's license itself in the hands of the driver is not itself a motor vehicle record because it does not pertain to itself. And
is a record something that is kept by an institution, by an organization, or the state? Is a record something that is kept on a continuing basis and an organized basis and consisting of a number of documents or files or whatever? Is that what we mean by a record?
It is, Your Honor. The word record's not defined in the DPPA, but the DPPA was modeled.
We go to the plain meaning of record, and I understand your argument to be that a record applies to something more extensive than simply a driver's license.
That's right, Your Honor.
I mean, I'm just trying to understand, is that the gist of what you're saying, that a record involves something more elaborate and something more systemic and something that doesn't involve simply a single individual or a single incident, but it involves either a state or it involves an organization of some sort that is creating records. And we talk about personnel records, for example, and those, when we use the phrase, well, is it in a personnel record? We're talking about a file kept by the organization that includes more than one snapshot document.
Yes, Your Honor. And the word record, that is the meaning of the word record under the Privacy Act, on which the DPPA is modeled. In addition, that's what the Supreme Court unanimously said in Reno versus Condon. And the best that the plaintiffs can say about that opinion is that it's dicta, or it's kind of ancillary as to what the Supreme Court is saying, speaking of the construction of the statute. But
The Privacy Act has different language.
I'm sorry.
The Privacy Act makes an explicit textual limitation to records maintained by an agency. There's no language like that in the statute here.
That's right, Your Honor.
Then why did you? You left me with the impression that you thought that this was the same as the language in the Privacy Act, but that's not the case, is it?
No, the connection with the Privacy Act is just that the word record is defined in that act and is undefined in the DPPA.
Well, so, but that could lead to two conclusions, couldn't it? That either you're just doing it once, or that the two are different.
Right.
Right.
In this case, though, the statute does that work by saying from a motor vehicle record as opposed to indirectly from or directly from. It just says from a motor vehicle record. And in fact, the statute was changed in committee. Judge Wilkinson noted a few years back in Anderson versus Hancock that one way that legislative history can be useful in a case like this is to trace words that were added or omitted from the statute in committee. Here, the key words in the House and Senate bill, the versions that came to committee, both would have expanded liability, kind of this downstream liability that the plaintiffs are asking for. But both of those bills were changed in the final version to make it clear that it must be obtained from a motor vehicle record. That change means something, and it limits the reach of the statute.
Well,
so one thing that, excuse me, Judge Motz, go ahead.
I was just going to ask you, so taking that language, where in the definition of motor vehicle record does the statute say that is only records held by the DMV?
That's right, Your Honor. It doesn't say in the definition of motor vehicle record, but because the word from, the work is done by the word from, that as several of Your Honor's questions earlier kind of direct, it has to be.
I didn't think that was the argument you were making, but maybe it is. Maybe you and I are saying the same thing.
Right. I mean, the information has to be from a motor vehicle record, and that has to mean direct. We know that based on.
Someone didn't get it from the motor vehicle record, and you say that even if what the other side says is a motor vehicle record, assuming arguendo, They didn't obtain the information from the motor vehicle record because it was downstream.
That's right. Even if a driver's license is a motor vehicle record, the plaintiff still can't win because my clients obtained publicly available accident reports that the state of North Carolina makes available for the public to view.
So that when you talk about what the state of North Carolina makes available, if one of my concerns here is that if we had adopted your opponent's view of this statute, we would be overturning a whole host of state laws which have historically made items such as this either to a greater or lesser extent available for public inspection. And you want to interpret preemption law with some caution and not just step into a situation where we're attributing to Congress a vast preemptive intent that at the very least doesn't seem to me to be clear and patent from the face of the statute. But can you elaborate on that as to what is the extent to which these licenses and crash reports are made available under state law for public inspection, and what are the reasons behind the states wanting to make these items available?
Yes, Your Honor. In North Carolina, accident reports themselves are public records from the moment they're created. And there's a reason for that. They are public records because it is in the public's interest to know if, for example, as in an earlier case, Mativi from 20 years ago, if the mayor is in a car accident, the public is entitled to know that and is entitled to pull that record and get those details. That's the public policy of North Carolina. Congress never intended for those state laws to be supplanted. This is a case, and this is a statute that is similar to what the Supreme Court described in CTS versus Waldberg, where Congress has indicated its awareness of the operation of state law in a field of federal interest and has nonetheless decided to stand by both concepts and to tolerate whatever tension there is between them. That is exactly what the DPPA does. And we know that because of the legislative history. We know it because of the B1 and B14 exceptions. B14 specifically enshrines any system of state law and state law public records that relates to motor vehicle safety. Those are specifically incorporated into the DPPA and preserved. Accident reports are probably the paradigmatic example of something that the statute is clear on. They are specifically exempted from the definition of personal information in 2725. The B1 exception specifically names law enforcement agencies and says that they are allowed to go forward and carry out their functions and use the information for that purpose. We know that accident reports were specifically contemplated. They're mentioned by name in the legislative history. They must be made available.
So in interpreting preemption law, it always makes me a little bit more comfortable when you can come to a view that preserves the efficacy of the supremacy clause, which, and at the same time, preserves the state's interest in police power under a federal system. And here the supremacy clause vindicates Congress's desire to protect against the worst abuses which occurred in the commercialization of the statute, or the commercialization of very private data, and at the same time giving effect to the supremacy clause that at the same time respects these state laws that in many, many states view it as a matter of the public interest. So we're striking a balance here and saying, yeah, the supremacy clause indicates a desire to overrule state law to some degree, but it didn't just want to wipe all state laws off the board.
That's exactly.
So you have a balance.
That's exactly right, Your Honor. And one of the things that the plaintiffs raise is that somehow allowing a state law like North Carolina's would eviscerate the statute. But we know that's not true because case after case across the country, the DPPA has worked. It worked in Marisich, where the lawyers went directly to the DMV. It worked in the Deisher versus City of Evansville case, where a police officer obtained information from a DMV for his own use. That's a Seventh Circuit case. It worked in Dahlstrom, where the paper went directly and tried to force the DMV to disclose information. The Kehoe case in the 11th Circuit, the Pickler case in the Eastern District of Pennsylvania. There's case after case where the DPPA works and plaintiffs win on summary judgment because there's just no dispute that somebody got the information directly from the DMV. Here, there's no dispute that the defendants didn't get the information directly from the DMV. Nobody contends that. And so this, in some sense, is just an open and shut case on that ground. The other thing that we know, Your Honor, is that Congress specifically contemplated the idea that other state agencies would need to use this personal information. We see that in the B1 exception, which allows law enforcement agencies and other state agencies to use the personal information in the process of carrying out their functions. We also know that that wasn't Congress's intent because of that legislative history. Representative Edwards, who was involved in the final committee, said that there was simply no evidence before the subcommittee that other systems of public records are vulnerable to abuse in the same way that DMV records have been abused. If Congress wanted to regulate other regimes, other public records regimes, they could. If the state of North Carolina wanted to lock up certain personal information or require redactions of accident reports, they could. There's a range of things that could happen. They just didn't in this particular case.
Is there anything further, sir?
Yes, briefly, Your Honor. To the extent that the Reno versus Condon case is considered to have dicta in its construction of the DPPA, even then, this court typically follows Supreme Court dicta and doesn't need to parse whether the Supreme Court was, a particular sentence is the holding or the dicta. An example of that is the NLRB versus Bluefield Hospital case, where a panel that included Judge Thacker said that we give great weight to Supreme Court dicta, as well as the recent Fusario case, which kind of gets into this question in a little more detail. Finally, in this case, we know that the statute couldn't possibly mean what the plaintiffs want because it would trigger a host of First Amendment problems. This court need not reach those First Amendment problems, but I want to touch on them briefly. We pose a couple of First Amendment challenges, but our core challenge is that if the plaintiffs are right, then our clients, as members of the public, are being punished by a civil/criminal statute for obtaining and reading reports that the government itself chose to make public. And that really matters in this case because the DPPA includes several exceptions that allow, for example, insurance companies to contact drivers after they're in an accident, but would specifically not allow law firms that could battle against those insurance companies to come forward and contact those same drivers. So the sticky constitutional problems should be avoided, of course, under constitutional avoidance doctrines. And instead, the statute shouldn't be read in such a way to trigger those constitutional concerns, which is exactly the position that the Department of Justice takes as well. If there are no further questions, thank you for your time, Your Honor. We ask that the district court be affirmed.
All right, we thank you very much. And I think, Ms. Mundell, you have 10 minutes and we'd be pleased to hear from you.
Good morning, Your Honors. May it please the court. Amanda Mundell on behalf of the United States. A plaintiff's DPPA claim turns on defendants' use of information contained in accident reports, which are prepared by North Carolina law enforcement officers, made available under North Carolina's Public Records Act. Now, defendants have raised a First Amendment challenge to applying the act to these reports, but This court, like the district court, does not need to reach those arguments because obtaining or using police accident reports does not implicate the DPPA. And I would welcome the court's questions on any of those points.
Maybe you can spell that out for me a little bit more.
Certainly, Your Honor. So I think as the court's questions have suggested, the defendants here obtained this personal information from a police accident report. They didn't obtain it from DMV records. And as I think everybody agrees, plaintiffs aren't arguing, or at least they hadn't argued below until motion for reconsideration, that those accident reports are actually motor vehicle records. So just under the plain terms of the statute, the DPPA doesn't apply to defendants' access or use of these accident reports. And as a result, we don't need to reach any of the sticky constitutional questions that defendants have highlighted.
One thing I've never been entirely clear as to whether the argument that the plaintiffs are making here pertains to motor vehicle licenses, driver's licenses, or whether it pertains to accident reports and crash reports, or whether they're arguing that in the alternative. I think, as one of my colleagues has brought up, the question of crash reports didn't make its appearance until the motion for reconsideration. And so is that a fairly clear instance in your view of sometimes waiver and forfeiture are confused? This seems to me a little bit more like, I thought waiver involved a voluntary act or something, whereas forfeiture involved just missing a chance or an opportunity.
Yes, Your Honor.
An example, seem more of an example of forfeiture to me, for failure to raise.
Yes, Your Honor. And I think it'd be useful to go back to precisely where plaintiffs had made their arguments about what the classification of this information is, whether they're arguing the accident reports or whether it's a driver's license. I believe if you take a look at, and I apologize, I don't know the JA site, but it's the ECF number 67 from the Gary case. I think plaintiffs may have affirmatively disavowed arguing that accident reports are motor vehicle records under the statute, and that would be an instance of waiver. But if they hadn't done that, I think Your Honor's correct. That would be an instance of forfeiture, simply not to raise it.
So this is interesting because you really have an instance of both waiver and forfeiture in your view.
I think that's right, Your Honor. I'd have to go back to double check exactly what they said, but Your Honor's correct. Whether it's waiver or forfeiture, we agree that they didn't preserve that argument for appeal.
They made it originally. A district court came out after the original argument was made and disavowed that, cast some cold water on that theory. And so they subsequently, I think directly, were no longer pursuing it, whether we call it waiver or whatever. Isn't that sort of what happened?
Yes, Your Honor, that does refresh my memory. I think that's correct. At that point, they shifted their focus. They didn't pursue that argument anymore.
Yeah.
Seeing no additional questions, Your Honor, we'd simply ask that the court affirm. Thank you for your time.
So, you're the expert on this statute across the United States. Have you argued other cases?
No, Your Honor, this is my first DPPA case.
So do you know whether there are other cases brewing?
I've seen some district court cases. I don't know if those have been appealed.
Yeah.
So I can't speak to those, unfortunately.
Okay.
Any further questions? All right, we thank you very much. Mr. Stradley, you've reserved some time for rebuttal.
Thank you, Your Honor. I'd like to address statutory. Well, I think first I'll start with Judge Wilkinson's question about the preemption situation. Congress has set the boundaries of the preemption in section 2721B, where it lists the 14 exceptions, and there is indeed a law enforcement exception, and there are other, 13 other exceptions there. But the Supreme Court has actually spoken on whether or not state law, the deference to be accorded to state law here. And in Marisich, the argument was advanced that, well, getting these, doing these solicitations was perfectly permissible under the South Carolina state bar rules. And the Supreme Court says that the fact that an attorney complies with the state bar rules governing solicitation does not resolve whether he's entitled to access the DMV database. And the court, and this is a quote, even if such a provision existed under the supremacy clause, it would not protect respondents from DPPA liability unless their conduct fell within one of the exceptions. And so while I appreciate the preemption concerns, the fact of the matter is the Supreme Court has spoken and said that Congress intent that the law needs to be enforced as written. And if that preempts some state law practices, then that is simply the consequence of the supremacy clause and Congress enacting this law. Now, I want to turn back though to a question about the interpretation of the statute. And the appellants are the appellees are advancing a view of the statute, which I think adds language to the statute. While the statute does talk about information from a motor vehicle record, it does not say information directly from a motor vehicle record. Directly is not in the statute. It says from a motor vehicle record. And if you read the definition of motor vehicle record, it is broad, does not do it justice. It is expansive.
Well, so what do you think is a motor vehicle record?
I think a motor vehicle record is the same thing Congress said a motor vehicle record.
Just instead of us arguing or discussing what Congress wanted, because people are divining what Congress's intention is. And as far as I know, we don't have them here with us. So why don't you just tell me what you think it is?
Your Honor, I think it is any record, anything that gets recorded that pertains to a driver's license, registration, or ID card issued by DMV.
So what is the motor vehicle's record that you want in this case?
Well, in this case, the information made its way from a driver's license or a database to an accident report, which indicates that it is the same as the information on the license, and then to a spreadsheet which defendants compiled or which they had compiled.
But you didn't get the information from a driver's license, right?
They didn't get it directly from a driver's license, but they did get the information from a driver's license in sequence.
They're going to putting the information in the crash report. Is that what you're saying?
Yeah.
Well, but the crash report, you've told us that you don't make a claim with respect to it. So I don't know where we are.
Yeah, sure, Your Honor. Where we are is the information makes its way from driver's license to report to spreadsheet that the defendants obtained. And those spreadsheets, because they contain information from a motor vehicle record back to the driver's license, those documents are motor vehicle records. And we have always argued.
But doesn't the word from mean anything to you? You think it like, I could say my family is from Ireland, which is true many generations ago. I think people would think I was lying if I said that my parents are from Ireland. Well, time goes by.
Sure it does. But again, Congress did not say directly from. Congress said from.
But it did say from.
Absolutely.
Did I understand you to say that the database that they created, that the appellants created, is a motor vehicle record under your theory?
Because it pertains to information
There's
from the driver's
limit to your theory then. What is the limiting principle?
Well, as stated by at least one district court, once information is protected by the DPPA, it is protected throughout its travels.
Has it been stated by any circuit court?
It has not been stated directly by any circuit court, but the Pickler court certainly found that information that was gathered through Westlaw and information brokers, not directly from DMV, and not by by the Judge Motz's definition of a motor of a document created by DMV. Those things cannot be. Westlaw is. If Westlaw is a motor vehicle record, then their spreadsheets are motor vehicle records, and that's what the Third Circuit found in the Pickler case. that information was protected, despite the fact it came not directly from DMV, but in sequence from DMV.
We know you were talking about congressional intent. I had thought that Congress considered and rejected a version of the statute that says obtained information is derived from motor vehicle. Are you familiar with that? Motor vehicle record.
I am familiar with that, Your
Well,
Honor.
doesn't that throw a little cold water on your argument?
Well, it does to some extent if the information is not, if you ignore the plain language of the statute. It doesn't say, again, it says
So you want to
from.
look at the legislative history when it helps you. But when it doesn't, you just want to look at the plain language of the statute. I'm happy looking just at the plain language of the statute, which talks about from.
Well, and Your Honor, I don't think that I've made a lot of legislative history arguments, but the fact of the matter is when at least when I read the statute and it says from, and I've got a circuit court opinion in Pickler showing that from does not mean directly from DMV. I've got section 2721 showing that Congress clearly intended to regulate this information after it leaves DMV because it regulates resale or redisclosure of information. When I add all those things up, it says to me that Congress has an intention to regulate this information at least to the point that we're dealing with the kinds of information that Congress had in mind, i.e. information involuntarily extracted from drivers, which is exactly what happened here. By statute, they were required to hand over their driver's licenses. They were not given the option to not identify themselves for obvious reasons. And Congress specifically enacted the statute to regulate information which is extracted from driver's licenses, as the court explains in Marisic and in Rena.
I don't know that I disagree with you about driver's license. Maybe they are, maybe they're not. But you didn't obtain information from a driver's license. Your clients didn't.
They did not. The defendants did not obtain information directly from a driver's license. They did obtain information that pertains to a driver's license, which is the definition that Congress adopted for a motor vehicle record.
All right, thank you. We appreciate very much your argument. I'm sorry we can't come down and greet you personally, but thank you very much for your respective presentations. And I think we will go ahead and prepare to proceed into our next case.
Thank you, Your Honor. Good morning, and may it please the court. My name is Sarah Saint. I'm with the Brooks Pierce Law Firm in Greensboro, North Carolina, arguing on behalf of the appellants in this matter. I appreciate the court's opportunity to be here. I want to start my argument where all parties agree. The appellants here in this case are public officials. The four appellants were all school officials at the time of the events in question. The teacher, Ms. Johnson, who is alleged to have actually harmed the student, is not an appellant. She is still a defendant in this case. So is her employer, the Board of Education. They are still a defendant in this case.
She pled guilty to something, right?
Your Honor, she did. She pled guilty to a misdemeanor assault.
Okay. So it's not alleged anymore that she harmed the student.
I suppose that's right, Your Honor. She pled guilty in 2019. I want to start my argument where the parties are coming to the podium not on equal footing. There is a presumption of immunity, even at the pleading stage, that a public officer takes their duties and performs them in good faith. There is a presumption here. North Carolina courts call this a cloak of office. They call it a shield that the plaintiffs must pierce. As the Fourth Circuit stated in 2018, every reasonable intendment will be made in support of this presumption. It places a heavy burden on the plaintiffs and the most exacting standard that these appellants could be held personally liable. The reason to pierce public official immunity must be alleged and proved. Alleged even at the pleading stage, and that is a high burden on plaintiffs. And because we're in federal court, we also have a plausibility standard here. The reason to pierce must be plausibly alleged, sufficient to overcome the heavy burden, not speculation, not conclusory. And that's what North Carolina courts say, with a much lower pleading standard.
So maybe you were clearing the table at the beginning, and maybe you can clear it one step further, because the district court seemed to think that because the defendants assertedly were engaged in ministerial duties, they did not have were not public officials. So maybe you could speak to that for a moment.
Yes, Your Honor. The district court found not that the public officials weren't public officials.
Correct.
They found that the actions were ministerial.
Right.
And they applied South Carolina law in doing so. We're in North Carolina. North Carolina must be applied. And well-settled North Carolina says that a public officer cannot be held liable for a breach of a ministerial statutory duty unless the statute expressly provides for that liability. The statute here does not expressly provide for that liability. So the court can decide a very narrow issue today, that even if the actions here were ministerial, applying North Carolina law, they would still be immune for those actions. The court does not need to reach the question of whether they were ministerial or discretionary. But if the court were to reach that question, these actions were clearly discretionary. The decision-making that was involved by the school officials required them to use reason and judgment and their experience not only as school administrators, but also interpreting statutes. This requires legal analysis, and that is discretionary, Your Honors. The reporting statute does not say if someone complains about a teacher called DSS. The statute says if there is cause to suspect child abuse by a parent, guardian, custodian, or caretaker, then call DSS. It's an important distinction here between making the decision and executing on an already made decision. The making the decision is clearly discretionary here. And that doesn't matter if you apply North Carolina or South Carolina law. And then the third way that the court should look at this question, the court should find what the district court did find, that there was no malice here, that public officials can be negligent. Public officials can even be recklessly indifferent. They cannot be malicious, and there are simply no factual allegations here that any of the four appellants here today are malicious.
Why do you say that if there is malice, the immunity would no longer attach? Is that correct in your view?
Yes, Your Honor. If there's allegations, factual allegations that the four appellants here were malicious.
Right. If there are plausible allegations that the appellants here were malicious, that would strip them of immunity. Okay.
Yes, Your Honor. That is correct. And malice.
Now, the question, a follow-up question I have is, based on the record before us, do we have enough to know that that these actions were not malicious?
Your Honor, as I stated earlier, the presumption follows the public officials even at the pleading stage. The allegations.
I don't dispute that. I'm just saying, let's just suppose, arguendo, that the defendants knew. I don't know what they didn't know. Let's suppose that they knew that this kind of abuse was going on, and that this individual, Miss Johnson or whoever it is, had a record of mistreating autistic children, and indeed all children. Wouldn't, if they knew it and didn't stop it and continued to let her teach there and moved her from one classroom assignment to another, would that qualify as malice if they knew of that autistic children were being stuffed into trash cans and that the school district did nothing about it?
I think Your Honor hit on an important question. The plaintiffs don't allege what the appellants knew, and they're required to get over the strong presumption. They're required to allege what it is that was known, what they think was the intent to harm. And that is crucial here, Your Honor, is that there must be intention that their actions be prejudicial or injurious to this student. And there are no allegations there. The hypothetical question, Your Honor, the court does not need to reach that question because that has not been pled by plaintiffs, and we have the complaint as it was pled here. But the important question here is looking at what was actually pled.
So you're saying that no matter what they knew, and no matter how horrendous the acts were, that there could be no malice as a matter of law?
No, Your Honor, that's not what I'm saying. I think there may be at some point a threshold that the plaintiffs might have alleged.
Why doesn't this reach that threshold?
Because all that the school officials are alleged to have known is that one person, upon information and belief, saw something that we're not sure what, and upon information and belief, reported that to the principal, who upon information and belief, reported that to the other three school officials. That's all we are alleged to have known. So even if somewhere up here there is that threshold of, well, now this knowledge becomes malice, we haven't come anywhere close to that threshold. The court doesn't need to reach what that threshold may be. These allegations don't reach that threshold. So looking at, again.
Well, let me ask this. Do we know exactly what they knew? This case was resolved at the denying a motion to dismiss and whatever. Would it help to have the record developed a little bit, and maybe we could find out something more concrete about what the defendants actually knew and what they didn't know? In other words, do we know enough about this case?
Your Honor, we know what was
just to dismiss it on the basis of immunity based on this record.
Public official immunity is an immunity from suit, not only an immunity from liability. It is immunity from going through the rigors of discovery. The plaintiffs must first allege that there is malice here, that there is intent to harm. Plaintiffs have not alleged that, so they don't get to go pursue.
And they amended their complaint once already, right? So they had an opportunity perhaps to make those allegations that would have been sufficient, correct?
That's right, Your Honor. They amended their complaint and they've had our motion to dismiss for over a year at this point. If there are factual allegations to be alleged that would get closer to the line that Judge Wilkinson is reaching for, is they had the opportunity to do that and have not even made that motion yet. If there were facts there, they would have pled them. And because this is an immunity from suit, not just liability, and because of the presumption, they have to allege facts to pierce. They have to allege malice. They have to allege intent. And North Carolina courts routinely dismiss on 12b6 where plaintiffs have failed to allege the malice element. In this case, at best, the plaintiffs have alleged negligence. They have not alleged malice here. They use abuse as if it's a silver bullet trying to pierce public official immunity without saying what was reported to whom and when. And the difference between malice and negligence is that negligence asked what should have been done, where malice looks at what was actually done, was actually pled, and asks whether those actions were intended to harm. They must be a deliberate, purposeful attack on the student. Plaintiffs argue what they think the school officials should have done, but they don't cross the line of alleging intent to harm. What they should have done is negligence and does not pierce the shield. Plaintiffs even...
Is anyone in a... Are you arguing that anyone in a supervisory capacity is absolutely entitled to the immunity because it is very, very difficult to prove that somebody in a supervisory capacity, as the remaining defendants are, would act with intent to harm? I mean, you can see that the teacher himself or herself could act with intent to harm by putting the child in the trash can. But are you saying it becomes much more difficult to allege that supervisors intended to harm simply by virtue of their knowledge? So that you can be a supervisor and you can recognize that the teacher intended to harm, but if you do nothing about it, then you don't intend to harm because you weren't the person on the scene. Is that your position, that supervisory officials, because they are one step removed, can never be accused or can never pierce the immunity because they didn't actually themselves intend to harm?
No, Your Honor, I'm not saying that at all. I think, as you pointed out earlier, there is a threshold somewhere up here where there may be a cross from negligence or reckless indifference into malice, into an intent to harm, even by a supervisor. We're nowhere close to that threshold. The plaintiffs in their brief argue that appellants seek immunity from their negligence. That's true. We are seeking immunity from negligence here, and that is what North Carolina public official immunity is for. Plaintiffs say that the appellants didn't act reasonably. They didn't act like a reasonable...
On the point about malice, what about the paragraph 100 in the complaint, the allegation that when all this came to light, that the IEP team, in essence, punished the student, saying that he was no longer allowed to attend school due to his maladaptive behaviors, which, of course, were the result of the abuse by this teacher. What about that allegation that it sounds like the student was being punished for his response to what this teacher had done to him?
Your Honor, there are no allegations that any of the appellants were involved in that decision. In fact, the appellants wouldn't be a part of a student's IEP team. They weren't a part of that decision. And we're looking at personal liability. There's no respondeat superior here. It is the personal liability of these appellants. And there is not intent to harm the student here. The only claims that remain here
are not an allegation of it.
I'm sorry, Your Honor?
There's not an allegation of it.
No allegations of it, right.
There may have been, we don't know because there's not an allegation of it.
We take the complaint at its face value of what those allegations are. The only claims that remain here are negligence claims. a negligence claim and a negligent infliction of emotional distress claim. And for negligence claims, public officials are absolutely immune unless there's an affirmative pleading of more than negligence, which is simply isn't the case here. And similar allegations failed in North Carolina, which again has a lower pleading standard. I'll give the example of the Webb case out of 2006, where a high school principal was alleged to have pulled a student through a window and pushed them up against a wall. He was the actor, the abuser in that situation, and the court determined that that was discretionary. There was no malice. The principal was dismissed on public official immunity on a 12C motion. The public officials here don't come anywhere close to doing what the principal did in that case, and the principal there was found to have public official immunity in North Carolina courts. Should the court decide that they would like to reach the question of was this discretionary or was this ministerial, which again, I don't believe the court needs to, because even if it was ministerial, there is no express provision for liability here. But if the court were to look at whether these were ministerial or discretionary, these are clearly discretionary. They involve the exercise of decision-making, of judgment, of their experience as school officials, as school administrators, and school officials exercise discretion like this, what to do in the face of complaints every day in determining what to do. They make these decisions through exercising the power of the sovereign, which is the point of the public official immunity. These are not rote tasks like wielding a shovel or closing a window. These are their jobs. They're the reasons they're public officials to begin with. And so when someone comes to them with an issue about a teacher, they must use their knowledge of experience and their knowledge of the law to determine whether or not this is a thing that needs to be reported to the Department of Social Services. And now, as we outlined in our brief, there's no reporting obligation here. When acting 7B, the legislature was focused on abuse by parents and by other folks in residential settings that take care of children there, not about other people, strangers, teachers, church workers. Those are
All right. Thank you very much, counsel. If either of my colleagues has further questions of you, I'm happy to wait, but otherwise we'll look forward to hearing from Ms. Cahagan.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. My name is Stacy Cahagan. I'm here with my colleague Elizabeth Horton on behalf of the appellees, RA, and her son, GA. Your Honors, the district court was correct. Appellants are not entitled to public official immunity based on the facts alleged in the amended complaint. Those facts, which we know even without the benefit of discovery.
So I do want to hear that, but I have this lurking thing in my mind about the basis for the district court opinion. So it seemed to me that the district court misunderstood what the status of these people are. Do you agree with that?
No, Your Honor, I don't. I believe that the district court found that even public officials.
No. You think that because public officials are doing some kind of duties that they cease being public officials? Is that what you said?
No, Your Honor, I don't contend that they cease being public officials, but we contend that they're not exercising discretion, and the immunity is afforded to public officials when they are exercising discretion. And importantly, when they are acting in a way that upholds the statute, that they are supposed, and the authority that's vested in them by the legislature. So
how can they not be exercising discretion? Because these situations arise in every school situation by the dozens, where parents and others are concerned about the children, the treatment that their children are being accorded in class, and this arises in special education classes as well as in other classrooms. And so these are, it's a hard decision as to whether to terminate someone, to have counseling or go through progressive discipline, or have them reassigned. There are dozens of options that school officials face in these kind of situations. And the situations arise with, quite not infrequently. And so how can this be anything other than discretionary to which the immunity would attach?
So, Your Honor, I would answer that question to say, had these appellants done any of the things that you just described that you would wrestle with in this type of situation, that would be discretionary and there would be immunity, right? But the facts are that they did nothing. They didn't investigate. They didn't take any actions. They didn't remove her from the classroom. They didn't report her to the state board, even after she pleaded guilty to 2 counts of assault on a handicapped person.
All right, now, where in the...
You can't, that's a different person, not the people that are at issue in front of us now.
That's correct, Your Honor, but these people are her supervisors, and these people are the ones under board policy that have the duty to make those reports. And the duty is a mandatory duty. These are mandatory reporters. And their board policy, policy 4240, makes...
Were any of them charged with failure to report?
No, Your Honor. And but their board policy says that anyone who has reason, right, who receives a report, and if there's any doubt, you resolve it in favor of reporting. And if you don't,
where are the allegations in your complaint about them receiving these reports?
So, Your Honor, they received the reports from Principal Clower, received the reports from Jennifer Bender.
No,
which paragraph is that in your complaint?
I'm sorry, Your Honor, let me look for you. So in paragraph 66 of the complaint, okay, we allege that Ms. Bender observed Ms. Johnson's abuse of GA and reported it to Appellant Clower. The district attorney and the investigators that investigated the criminal matter reported to GA's mother that this was reported all the way up to the superintendent, and that all of the administrators knew and did not take action. And then the district attorney and the sheriff's department didn't pursue a failure to report against any of these people. To my knowledge, they did not, okay, Your Honor. Okay. But they did, but that was something that at this point, without the benefit of discovery, we don't have access to that underlying investigative record. Okay, we don't have access to the information about what they knew, what exactly was reported, the things that they're putting forth. What we do know is what the police were investigating. We do know that they were investigating him being put in a trash can repeatedly, okay, and told if you act like trash, you'll be treated like trash. We know that they were investigating him being held down and smothered, okay, with her hands and nose, with her hand over the mouth and nose. Okay. We know that she spilled the hot grease on his head. We know that they were investigating whether her forcing him to stand, not giving him a desk, and forcing him to stand inside of a taped square. So, and
these are terrible facts, terrible. I think that all of us are parents here. Maybe not the other people in the courtroom, but everybody on the bench is a parent. But the state of North Carolina has seen fit to give immunity, a pretty broad immunity, to public officials. And you recognize that these 4 people are not the person that did this, but public officials. Let me just say that under we grant immunity, qualified immunity to people that shoot, policemen that shoot somebody else because of the instance, because of the immunity. And so even though these are terrible facts, you have to grapple with the immunity.
Yes, Your Honor, and I believe
then they just because you have terrible facts, think of the relatives of the person that shot, worse facts, and still the officer gets immunity.
Yes, Your Honor. And And we want public officials to act in good faith, right? And we want them when they're
Public officials don't get immunity only when they do the right thing. That's just, they don't need the immunity then.
but they only get immunity when they exercise discretion.
Right.
And Your Honor, we are not.
So this
here-
is all about they don't have discretion? I thought all your argument was, when you were telling us these facts, is that they did have discretion to do this, to report it, et cetera, and they didn't do it. So what is your argument? Is your argument that they don't have any discretion?
So, Your Honor, according to the district court, okay,
I'm not asking, I'm asking for your position.
So-
If you embrace the district court opinion, if that is some substance of what you're going to argue to us, that's fine. Because I understand what the district court said, and we can make our assessment about whether the district court was right or wrong. I thought maybe you had some other or even alternative argument to make.
We do, Your Honor. And so if Your Honors are not inclined to accept that it was ministerial, okay, and that the duty was absolute, okay, and that they were exercising discretion, then we have properly pled the exceptions, okay? We have properly pled the exceptions, okay, to pierce that immunity.
And what exception have you properly pled?
We have properly pled malice.
Where?
Okay, where's the word malice in your complaint?
So, Your Honor, we pled the facts that support malice.
Where?
We pled,
The whole thing?
no, Your Honor, not the whole thing, but we did plead that we pled all the times that they did not report. We pled that they received the information. We pled that they did not report. We pled that they had the intent to harm. And the
Okay,
facts
where is the
show
intent to harm?
Intent to harm, where is that?
that it is pled over and over
Okay,
again.
just
Where are the
give me
words?
one or two instances.
Yeah,
If it's over and over.
so we pled, okay, in paragraph 156, that any rational principal, EC director, associate superintendent, or superintendent would have taken immediate action to stop the abuse and to prevent future abuse.
Oh, I thought you said you pled intent to harm.
So, Your Honor, the intent to harm is also found to be through constructive intent. When you choose to do nothing, when you have these facts and you choose to do nothing, you choose to keep it quiet, and you.
So where is the word intent, constructive or otherwise?
So, Your Honor, in paragraph 158, we pled that she ratified that by failing to take corrective action, they ratified her conduct and allowed the continued abuse of GA and also of other.
So
districts.
the word intent or constructive intent or malice isn't in there, it's ratified.
It's ratified, Your Honor, but I think.
158 doesn't say anything about ratifying. Oh, there, yes, I
Yeah.
see. Therefore ratifying
Mhm.
conduct. Okay.
And Your Honor, we pled in paragraph 161 that they turned a blind eye. They took no corrective action and they allowed the abuse to continue. Okay.
All right, now what North Carolina cases are there that strip the immunity from school officials for a failure to report or a failure to take corrective actions? I wanted to give me what North Carolina cases are there that strip the immunity from supervisory school officials for a failure to report or a failure to take corrective action.
Your Honor, what I think is instructive on that is that all of the cases that afford immunity point to what the officials did. They point to the investigation that they conducted. They point to the actions that they took, and they find that those were sufficient.
No. But what I'm concerned about are sins of omission, so to speak. And where has the immunity been stripped from school officials for sins of omission? From failure to do this, or failure to report, or failure to take corrective action, because the malice is generally associated with some active intent. And what I'm concerned about here is that you are making a leap from an active intent to harm to a failure to correct a harm. And I want to know where the North Carolina case law strips the immunity from a failure to take corrective action, which is what really, it seems to me, the gravamen of your complaint is. Now, you need to tell me what North Carolina case law backs you up.
And so, Your Honor, there are no cases that we have been able to locate that specifically say in the school context, okay, that the failure to report or the failure to take corrective action. But there are cases, okay, the Chastain case, okay, that is briefed, where you have the law enforcement trainer, okay, that discharges the loaded firearm. And in that case, the court found that that is constructive intent. There's no way to know that.
Oh, you know, I was always taught in law school that constructive intent or constructive discharge meant no intent or no discharge. And constructive could be a fudge word when there's no active. So but you're saying that you are admitting that in the school setting, there are no North Carolina cases that have stripped the immunity from school officials, supervisory officials, for a failure to take corrective action. And the reason I ask that question is the cases that are out there in the woods must be absolutely legion if you can interpret malice in the school setting to mean a failure to take corrective action. Well, they're parents and students and people all the time who think school officials are negligent for failing to take corrective action. So I'm just asking you, aren't we, if failure to correct strips the immunity, aren't we taking a big leap under North Carolina law?
So, Your Honor, we have the Smith v. Jackson case, right? And in that case, there was the failure to report, right, to DSS. It was concealment, it was cover up, there was abuse that the SRO was aware of and did not take action. Now, again, but my colleague seeks to distinguish that and says, well, it's the public duty doctrine. But the public duty doctrine serves the same purpose. And in the Smith v. Jackson case, they make it clear that this blanket immunity that does not serve what the purpose of immunity is. Okay? And I do think that that's one thing that is important to come back to, is what is the purpose of immunity? Okay? The purpose of immunity, and this is something that's afforded, had they reported, had they taken any action, they have statutory good faith immunity under Dobson. Because Dobson court made clear, if you report, you have immunity. So there's no chilling effect that's going to happen here of people not reporting abuse and thinking that, oh, well, I might get in trouble for that. We want people to think that they might get in trouble for not reporting abuse.
But there are many instances where someone could be, didn't feel a need to report. I mean, maybe they didn't feel the incident was that serious. Maybe they didn't feel it was a credible allegation. Maybe they felt that they didn't believe it because the teacher was a very good teacher. So I can see a lot of reasons why someone would fail to report in good faith, and a failure to report, as opposed to active infliction of harm, a failure to report is much more likely to be discretionary. Is that not right?
I would agree with that, Your Honor, but I would agree that in the face of these facts, that we pled that was not the right decision. It was malicious to turn the blind eye to that over and over again.
But you didn't plead maliciousness.
We pled what the standard was, Your Honor, and we pled facts supporting the malicious
What do you
behavior.
mean? But does the word malicious appear in your complaint?
It does, Your Honor, in terms of what the standard is, the Grad-Picasso standard.
The word malicious appears in your complaint. That was Judge Motz's question. Does the word malicious?
Yeah, she says it does.
Yes, Your Honor.
Where is it?
I'll find the paragraph for you. Okay. But I do think that, and while I'm looking.
So when you set out the standard, the word malicious.
Yes, Your Honor.
But you did not make allegations that what happened here met the standard, i.e. malicious.
Your Honor.
I see what you're.
But, and when I think, if you look at the cases where someone makes a conclusory statement that says they acted with malice and there's no supporting allegations, those cases are dismissed. That's
well,
not
so you decided not even to put that in. So how do you evade dismissal that way?
So I think we evade dismissal because we have the facts that support the malicious
But you have to say that you regard, or you're alleging that they acted in a malicious manner, and then explain why that's malicious.
And we
that's what a complaint should be doing.
Yes, Your Honor. And we alleged corruption. We alleged that they purposely sought to conceal this. I mean, we alleged that at every opportunity, they failed to take an action. We alleged that they put her with more disabled children. We alleged that they continued to employ her even after she pleaded guilty. We alleged that they lied to the parent. All of those actions constitute malicious actions. And I think it's improper to say, well, if you only put one sentence, that's not enough. But if you have a fact-rich complaint of malicious actions and the intent for this to continue and for the harm to happen,
Do you have intent in it? See, the thing is, all of those actions maybe were malicious, maybe they were just a mistake. They were just, that they weren't malicious at all. These people just weren't very good people, good administrators. They were careless. Careless is different than malicious.
Careless.
Right? And those facts don't tell us one way or the other. And we have no allegation from you that we're one way or the other.
And so, Your Honor, those claims, we survived the motion to dismiss. To the extent that it's necessary to go back and to write, they acted with malicious and it was their intent, and to add that to the complaint and to amend to say that, I mean, we certainly can do that. But the facts that are there.
But the fact that you survived a motion to dismiss doesn't stand on appeal. You understand that, right?
I do understand that, Your Honor. Okay. That was why our first position is that public immunity, okay, public official immunity is afforded for discretionary acts, okay? And mandatory reporting is not a discretionary act. Mandatory reporting says, if you know, and I think if you look at the recent decision from this court in Doe in reporting the Title IX, when you receive a report that objectively is reasonable, that it would constitute sexual harassment, or in this case, that it would constitute child abuse. When you receive that report, you have a duty then at that point to take action. And here they did not do that.
And did you plead that in your complaint, that was contrary to some sort of state law?
Yes, Your Honor, we did. We pled that it was contrary to state law. We pled that it was contrary to Board of Education policy, contrary to the school board policy.
And you cited all those things?
We did, Your Honor. And we
not just said it's contrary to...
No, Your Honor. We specifically outlined what those duties are, and that by not reporting, that it was contrary to those duties. And the duty under the board policy 4240 informs them. If you don't report, you are subject not only to discipline at school, but civil and criminal liability. And so, Your Honor, I realize that I'm almost out of time.
Do we know this woman, the abuser's conduct ultimately was reported? Do we know, and by some, as I understand it, some employee in school? Is that correct?
That is correct.
Okay. Do we know the timing of that?
Yes, Your Honor. We know that was reported when he was 6 years old, when he was in first grade.
Yeah, but that doesn't. Do we know the timing of that vis-a-vis when the defendants who are at issue here knew about it?
Yes, Your Honor. It was once that Miss Bender reported when he was in first grade, she informed Appellant Clower, who was here, and then Appellant Clower informed the other appellants. So if that was in first grade, Miss Johnson continued as his teacher and continued the abuse.
Was it reported to the sheriff's office?
It was reported to the sheriff's office when he was in third grade, right? And that was when another student, and I think it's an important fact, and I realize that I'm over my time, and if I could just finish, okay, is that when someone who was not in the district heard this very same thing, put them in a trash can, treat them like trash, they investigated and they reported it to the police. The police investigated and they charged her with 2 counts of assault on a handicapped person, and she pled guilty.
We understand those facts. What we are trying to do is to see if these 4 people are entitled to immunity under North Carolina law. And so telling us all these facts, if you don't allege, as I don't think you allege malice in this complaint, and if you don't allege some other exception that would put them under North Carolina law,
So Your
then
Honor,
they're entitled to the immunity.
and I don't and just respectfully, if we allege that they were in conspiracy to cover this up, I think that it's also corruption. Okay, if we allege that these actions and the continued decision to put her back in these same environments with disabled children, okay, that is the intent that we need. And Your Honor, we would respectfully, I'll just to close, okay, we would respectfully ask that this court uphold the decision of the district court and find that they are not entitled to immunity at this stage. There may be evidence that comes out in discovery that shows that they are entitled to immunity, that they really didn't know, that they did investigate, that the police were lying. That could happen, okay? But at this stage, we have facts that for 2 years they knew about this abuse and they did nothing. And to find otherwise undermines not only the statutory intent, but it also invites school officials to turn a blind eye to abuse and to refuse to report those that are found guilty of assaulting children and to improperly use the cloak of immunity as a sword rather than a shield.
Okay, well, this is a definition of malice. To allege that a public official acted with malice, a plaintiff must allege flat facts showing that the defendant, quote, wantonly did that which a man of ordinary reasonable intelligence would know to be contrary to his duty, and which he intended to be prejudicial or injurious to another. So there has to be intent, and I think you have to plead intent.
And Your Honor, our position is that there is intent by doing nothing and by ratifying the abuse. There was the intent for it to continue.
Intent to injure. By
The
doing nothing.
intent to injure because they knew what she was doing and they continued. And then they put her with more vulnerable children. And even after she pleaded guilty, they kept employing her. That is an intent to continue to injure. And Your Honor, we believe that the facts in the amended complaint support that. Okay.
Thank you.
We thank you very much. Ms. Saint, you have some rebuttal.
Yes, Your Honor, thank you very much. I will be brief. As the court has recognized, this presumption is quite burdensome for a plaintiff. They must allege facts, not mere speculation, to overcome this presumption. The presumption means that, or presumes that they made reasonable decisions. These are troubling facts. They're not what we want to see in our public schools, but plaintiffs cannot get discovery on mere upon information and beliefs about knowledge. This is an immunity from suit, not merely immunity from liability. The plaintiffs claim here that the appellants made a bad decision. We could have walked in here today and admitted negligence, and the public officials here would still be immune. They could have gotten it wrong. They could have made a bad call. They could have done more. This could be not the right decision, but that's simple negligence for which these public officials are immune. There are no allegations here to pierce. Plaintiffs have not pointed to any allegations showing this intent to harm. There are no allegations of this intent to harm. There's no allegations of collusion, of collective intent here either, though I believe that corruption has been waived as a piercing exception. They're just simply...
Ms. Saint, how do you deal with the fact that the facts here that were pleaded are really pretty terrible? We say other on the appellant's brief, I say other elements of Ms. Johnson's physical and emotional abuse included spilling hot grease on J.A. He was stuffed back into a trash can when he tried to get out. His nose and mouth were covered on multiple occasions. She made him stand for hours on end, which is, and the brief claims that this was a known method of torture. Why does that not, if you didn't use the magic word, but why does not that kind of treatment indicate malice?
Your Honor, it may indicate malice on Ms. Johnson's part, but she's not an appellant. Here, what was allegedly known by these defendants, again, upon information and belief, was something that happened in the 2017-2018 school year. That could have been an instant of restraint. That could have been an instant of being in the trash can that wasn't standing at a desk or without a desk, or the collard greens incident. That was the following year, and there are no allegations that any of these appellants, that was reported to any of them. But again,
I'm sorry, so say that again. The only thing that they knew was
I'm sorry, Your
the
Honor.
first short trash can incident. Is that it?
We're not entirely sure what they knew, but
Well, what is alleged in the complaint?
well, what was alleged is that they knew about the abuse, and we don't know what the abuse means. That's a legal conclusion. We don't know what the facts are that were reported allegedly upon information and belief between Bender to Kluwer to the other
I thought
three.
you just said that they didn't know about the second.
That's right, Your Honor. So the
How do you
allegation.
get that if the complaint says the abuse?
The allegation of the report occurred in the 2017-2018 school year. In the 2018-2019 school year is when the allegations about the standing or not having a desk, that happened the following school year, and there are no allegations of any reporting the following school year.
All right, so I gather what you're saying here is that if the teacher, Ms. Johnson or whoever was the defendant here, that this would be a very different case. But because the case is brought against school officials, it moves it from an active intent to harm to a failure to report case. Is the linchpin of your position that if the teacher were an active defendant here, that this would be sufficient to plead malice, but when it goes up to the supervisory stage, it becomes a failure to take corrective action case. And your view is that's not sufficient to plead malice. It all depends on who the defendant is.
Yes, Your Honor, I see him over time, and if I can answer your question, I think it's very important about who the defendant here is here. The teacher is, to liken the police shooting case that Judge Motz brought up, is like the police officer who did the shooting. But in those cases, the police officer is an official. A teacher is an employee. A teacher doesn't have public official immunity whatsoever. There doesn't need to be an analysis of whether her actions were malicious or not. What is required is an analysis of these school officials' actions as being malicious. And there are just simply no allegations that they did it with an intent to harm the student.
It was a failure to take corrective action case.
Yes, Your Honor. It is a failure to take corrective action case based on, we're not sure what the knowledge was of these school officials, but in any event, the argument is that they should have done more, and should have done more is a negligence question, not a malicious question. And so there are simply no allegations of this intent, and the court should find that these school officials have public official immunity, reverse the district court, and allow the case to proceed against the teacher and the remaining defendants.
Well, of course, the problem is it's here in 12B6 motion, right?
That is correct, Your Honor.
So they haven't had an opportunity to talk to these people, to find out what the intent was and when they did know these things.
That is partially correct, Your Honor. There are ways in the public school environment and in the public environment generally to request records to get information. There's the Family Educational Rights and Privacy Act. There's the FOIA Act, where they could have gotten information.
Did they do that?
Not that I don't know, Your Honor. I don't know whether they did that or not.
Your client would know that.
I'm sorry?
Your clients would know that.
My clients, most of them no longer work for the district anymore. They're not involved anymore.
I have represented state agencies too, but there's somebody that you're talking to as a client.
Yes, Your Honor. And I don't know that fact to give you, Your Honor, if they did or did not request records, but they could have. And what is required is that they allege the intent. They must have done their due diligence because of this presumption. The presumption is so high here for public official immunity that the allegations have to be made at the 12B6 stage, not only at the summary judgment stage, because this is an immunity from suit. You don't get straight to discovery simply because you allege upon information and belief, because you think you need more information. You have to have enough information to allege malice in your complaint in order to get over the presumption. That is the whole purpose of public official immunity and the other immunities from suit. The court has no. Thank you.
Excuse me, counsel, if there are no further questions, I want to thank you and both of you for an interesting and spirited appellate argument. And as I mentioned to previous counsel, we're sorry we can't, that the state of the virus prohibits us from coming down and expressing our appreciation to you personally, but our gratitude to you is no less. So thank you so much. And we will take a brief recess, a 5-minute recess.